Two parties on the appellee side. Have you talked about dividing your 20 minutes? Anyone?
Your Honor, I did not have an opportunity to talk to Mr. Frazier about this morning just due to time limitations, but I would suggest that we limit to 20 minutes, maybe 2/3, 1/3, only 1/3 to me, Your Honor.
Unless Mr. Fraser has an objection, we'll go with that.
No objection, Your Honor.
Okay. All right, Mr. Landkamer, you're up.
Good morning, Your Honors. Counsel, may it please the court, John Landkamer for Appellant Nasman Enterprise, Inc. Appellant request to reserve 5 minutes for rebuttal.
Sure.
This case on appeal involves appellant's rights as a tenant of desirable units in a shopping center owned by the appellee landlord. The issues in this appeal address the trial court's dismissal of the claims of appellant's operative complaint with prejudice, denial of appellant's motion to amend, and denial of appellant's motion for rehearing. The appellant requests that this court reverse the trial court's dismissal order and rehearing order with instructions to the trial court to provide leave to appellant to amend its complaint in conformance with this court's findings and conclusions. A brief synopsis of the alleged facts in this case that only made it as far as the pleading so far. In 2017, the appellant purchased the assets of an existing grocery store located in a shopping center owned by landlord appellant, the shopping center owned by landlord appellant, which grocery store had previously itself been owned by the landlord. In addition to paying valuable consideration for the improvements in the grocery store, the appellant actually paid the landlord an additional $100,000 that was due from the prior tenant to the landlord in order to get the right to execute a new lease. Appellant negotiated a long-term lease with the landlord. During the negotiations, the pleadings show the appellant repeatedly requested and confirmed that it would have an exclusive right to operate a grocery store in the shopping center. And the landlord repeatedly promised the appellant the exclusive right to operate a grocery store in the shopping center. Based inter alia on the landlord's representations and the appellant principal, whose primary language is not English, his reading of the paragraph 4.1 of the lease, the title of which is use of the lease premises and exclusive right, the appellant reasonably believed that the landlord provided the appellant with exclusive right to operate a grocery business at the shopping center.
Mr. Landkamer, let me jump in because I think we're all familiar with the facts. And I know that this court has already denied the motion to dismiss for lack of jurisdiction based on the landlord, but I'm not convinced that we have jurisdiction over this appeal with respect to the landlord. So can you briefly discuss that jurisdictional issue?
Your Honor, I believe that I had not looked into this precisely in quite some time because the court had previously denied the motion. However, going back, I know that the court found that it had the appeal will proceed pursuant to Florida Rule of Civil or Appellate Procedure 9.110K.
I understand that, but how can we do that if there's still the my understanding is the landlord still was granted leave to amend the debt count, and it seems to me that that count is inextricably intertwined with all of the other counts, and so at least with respect to the landlord, I don't see how this can proceed even as an appeal from a partial final judgment. Certainly with respect to the competing tenant, but I'm not sure how with respect to the landlord.
Your Honor, the landlord, the DAC action, I don't know that it is inextricably intertwined. There are other issues that come up in the DAC action concerning the tenant's rights.
Well, isn't it
Even
basically,
though if there are other issues that come up, there are still intertwined issues, are there not?
There are intertwined issues, yes, Your Honor. I completely agree with that. The court knowing the facts, I'll proceed, and I guess the court will do what it's going to do is to jurisdiction. The procedural history, I think, is important here. There was an initial complaint filed in October 2019 by the tenant after it had been such things as the landlord collecting 5 months worth of rent checks, not depositing any of them, and then going ahead and depositing them all at one time after having given the competing tenant a lease on the next door property to open up a supermarket and a right of first refusal on the tenant's space. It was clear that the landlord, from the allegations, was fostering Bravo Supermarket as a superior grocery tenant, wanted them in the tenant's space, and was looking to cripple its operation and force a default. Based on that, the appellant filed this action trying to protect its interests. And on October 9th, 2019, landlord filed a motion to dismiss. The tenant, as it was able, having no pleadings filed its first amended complaint in November 2020. That first amended complaint for the first time brought the competing tenant in as a party under claims that the competing tenant was tortiously interfering, and there was civil conspiracy going on between the landlord and the tenant. Those claims, the motions to dismiss, were filed in a motion for summary judgment by the landlord. The discovery wasn't being answered by the landlord that was being propounded. Tenant then changed counsel in January and February of 2020. In March of 2020, the appellant, filed a motion to overrule the objections to the discovery and to compel responses. Later in March, the appellant moved to get relief to file a second amended complaint. The second amended complaint had new counts and also basically dismissed without prejudice, did not include the claims against the competing tenant. The first amended complaint had 4 counts: breach of lease, tortious interference with a contractual relationship, civil conspiracy, and reformation. The proposed second amended complaint included 5 counts: an injunctive relief claim, a breach of lease claim, a declaratory judgment claim, a fraudulent inducement claim, and a reformation claim.
And Mr. Landcamer, in the first amended complaint, the 2 counts that did name the competing tenant, those are directly premised on the assumption or the argument that there is this exclusive use agreement, correct?
I think that in the first iteration, there was a third amended complaint proposed as part of the rehearing, or motion for rehearing. The third amended complaint had brought up additional issues that may have projected onto the competing tenant, appellee. But you are right, in the first iteration, in the first amended complaint, yes, they completely settled on whether there was an exclusive use right in the complaint.
And what was I'm sorry, I can't remember offhand, the proposed, never mind, I've got it, sorry.
Mr. Landcamer, what is the present status of, say, count 4 under the proposed second amended complaint? That has been dismissed?
Count 4 under the second amended complaint.
The fraudulent inducement count?
Yes, it has been dismissed with prejudice.
Okay. My concern with that count was under fraudulent inducement, as I understand it, the contract becomes voidable. It's not void. And theoretically, your client would have to make a choice, that is to rescind the contract or to elect to proceed under the contract. The latter course seems to be rather difficult, since there's a contract 4.1 says there's no exclusive rights. So it would appear that under fraudulent, if you're successful, you would rescind. Is that correct?
Your Honor, the wherefore clause in the that count requests damages for the fraud. So.
Well,
if
it does
there was-
more than that. It requests attorney fees, consequential damages, which suggests that it's being cloaked as a stalking horse for a breach of contract claim. Because to get attorney fees, you need either a statute or a contract. And this is a tort. So I'm trying to figure out what theory you're going under and whether or not you could actually, if the trial court is in error, plead account for fraudulent inducement by saying, we would, if we're pursuant to the Supreme Court's decision in Mazzoni, elect to rescind the contract and sue for our damages, which is the 100K that you mentioned in the count. And that would be it, probably, because that's what you'd get for the tort. There's, but with the prayer for relief for attorney fees and all this stuff, it almost sounds like it's a contract case. I'm trying to figure out if you elected to proceed under contract, where you would go when 4.1 doesn't give you an exclusive right. It's clear on its face that there's nothing there.
Your Honor, I believe that the fraud claim would, if the damages, if that was all that my client had at the end of the day, my client would seek damages for fraud in the full extent of the law. All these claims are pled in the alternative. They are, which is part of what the rules of civil procedure provide. So if my client, backed into a corner, pleads fraud and the inducement, there are other bases for
You're
attorneys.
asking us to grant you, reverse the trial court and say, allow you to plead the fraud and the inducement claim and make it more precise in terms of when you're going to make the election, or that you would intend to make an election under Mazzoni. And there's even, I saw last night, there's even another case that came out of the third that's not even final yet. I think it is third. I don't remember now, but I've got it to plead it. I mean, I'm trying to figure out how, I'm concerned that there's the mixing of remedies and the election hasn't been made yet.
I understand. I think that election of remedies under the case law doesn't have to occur at the beginning of the case. It would
I
only happen
agree.
before judgment.
I agree. It's just a question of what's pled and how it's pled. And probably what the trial judge is seeing here is maybe you are making an election with your wherefore clause, your prayer for damages, that is leading to a conclusion that some of the cases saying that all these things are the same damages of the breach of contract and you can't do it. Whereas the fraud and inducement is for conduct that occurred before the formation. And I'm just wondering if there's a clarity need here or whatever. I don't want to take up your time on that, but that's what I'm trying to figure out, where we're going and what you're looking for us to do.
Your Honor, I think on the fraud and the inducement claim, pled in the alternative, I would be more than happy to clarify and clean up that language if given the opportunity before the trial court. I think at this point on the pleading stage, it was too early to do so. My client had never had an opportunity to hear the trial court.
Well, I understand it's too early to make the election. I'm just trying to make sure that the pleadings for amendment purposes are right. And I'm trying to make sure I understand that what the trial court was doing and whether or not there was a concern that this was merely the same damages, which suggests trying to avoid the statute of frauds.
And there was nothing about that on the record.
Okay.
The statute of frauds, I do not believe it's part of my brief that the
It
case
wouldn't
law
apply to a
about the
fraudulent
statute of
inducement claim.
fraud they're not on a fraudulent inducement claim. The
That is- Okay.
case law that was cited by the landlord appellee is not in play here. There's a distinction with a huge difference. In the Cannell case and others, the distinction was drawn by the fact that there was separate beachfront property. So the appellants in that case had bought property. They were told that they were going to get beachfront access to somewhere in this development. And the Cannell court, the Supreme Court in Cannell, determined that that was going to be an easement and that they didn't have that right because the statute of frauds applied to it. In this case, it's different. The statute of frauds have been complied with. There is in fact a lease. We're not talking about separate property. Fraud and the inducement is not precluded by the parole evidence rule under these facts. I do think it's important to mention when we're talking about denial of a motion to amend, talking about Grover versus Carl. Grover versus Carl, second DCA opinion from 2015, quoting, All doubts should be resolved in favor of allowing amendments so that cases may be resolved on their merits. Thus, as a general rule, refusal to allow amendment constitutes abuse of discretion unless it clearly appears that allowing the amendment would prejudice the opposing party, the privilege to amend has been abused, or the amendment would be futile. The trial court never found that amendment would be prejudicial or the privilege to amend had been abused. The record wouldn't support that. The trial court at the hearing never used the word futility. That word didn't show up until the order proposed by counsel for the appellees. There's some case law that would suggest that creates an issue with due process. My client did the opportunity to argue whether or not amendment would be futile, because the word futility was never brought up in the context of the dismissal hearing.
Okay, Mr. Montgomery, you are at your 15-minute mark, so if you want to save your 5, you proceed as you wish, but you have 5 minutes.
I will reserve my 5. Thank you.
Okay. Gentlemen, which one of you wants to go first?
Mr. Vaughn, would you like to go first?
However you want to handle it, Mr. Frazier. I assumed you would go first, but.
All right, that's fine. I'll go first.
Okay, you're
Good
up.
morning, Your Honor. David Frazier on behalf of the appellee, the landlord, I'll refer to it as in this case. I would just quickly address, respectfully, Judge Casanueva's point first. A fraudulent inducement claim exists if it is a false statement of existing fact. What we can't do, and in Cannell said this, the Supreme Court said this in Cannell, that a false statement of a future oral or an oral statement of a future promise can never be the subject of a fraudulent inducement case. Here's what Cannell said. The plaintiffs are relying upon a mere oral promise to create the easement, which is clearly within the statute of frauds. It goes on to say, since the provision in the statute prohibiting any action to be brought on an oral contract within the statute includes actions based indirectly on the contract, an action for damages cannot be maintained on the ground of fraud in refusing to perform the contract, even though the defendant at the time of making the oral contract had no intention of performing it. I then cite other cases that, or actually counsel cites several other cases that talk about where you do have a fraudulent inducement claim in those involving leases or other items that fall within the statute of frauds. And that is when an existing statement of fact is fraudulently misrepresented. And I can give the court an example. If, for instance, my client has a Hungry Howie's at the plaza, and Hungry Howie's likes to be at places with Taco Bell, differing food groups, and I tell them I have a letter of intent with Taco Bell, that would, and it turns out to be false, that's a statement of an existing fact. But as our court said in Cannell, if it's a statement of a future promise, that oral statement will never serve as a basis of fraudulent inducement, which is exactly what, and actually I cite the Cawley case that explains or goes a little further on Cannell, and it says in Cawley versus Reball, because we conclude that the breach of contract is barred by the statute of frauds, the action for fraud is also barred as well. So you wouldn't be able to get damages. Those are looking at future promises that fall within the statute of frauds. So if it's a statement of existing fact, they can bring a claim for fraudulent inducement. If it's a statement of a future promise, they cannot. In this case, they're arguing that they were promised a future restrictive covenant. Oral, again, there's no writings on this, just at the time of lease, they were orally promised a restrictive covenant. Now, Judge Casanueva used the word cloak. Are we trying to cloak a breach of contract claim as fraudulent inducement? And if you do look at what was in the second amended complaint, they are asking for all kinds of attorney's fees. They want general and compensatory damages, consequential damages, special damages, prejudgment interest.
That was my concern, to find out what this really was. What
Right.
would you really be pleading, and what would be your option? Because I could not see from the face of this pleading, if you're going to rescind mean, if you're going to have a fraudulent claim, assuming you had one, why you would elect the contract when it 4.1 is pretty clear. So then you are left with rescinding it. And what is the element that you're looking for? And I was just trying to find out what we were doing and how you could possibly amend it, but I wanted to find out if there was a possibility so that it would not be futile. So I was just trying to play with them to see what was going on.
Right, and that's an excellent point. In the appellant cites to the Tonwell Enterprises versus T&J, and also Tinker versus D. Maria, where it talks about they're dealing with contracts that fall within the statute of frauds and fraudulent inducement. However, both those cases dealt with rescinding the contract. They have the right to rescind the contract. They can rescind it based upon a fraud inducement claim. But what they can't do, mind you, they've never asked to rescind the contract, and the trial court can only do what they've been presented with. They never sought leave to give a rescission of the contract. Even in the third amended complaint, motion for leave, and this is Judge Rothstein's jurisdictional point, that they have a pending motion for leave to file a third amended complaint right now in the trial court. With respect, I think that the court does lack jurisdiction because they raise all these same points in the motion for leave to amend, and the trial court says, I'm not going to hear that until I hear from the second district. So we've been sitting in a limbo holding pattern. But anyways, even in their third amended complaint, they don't say, Judge, let us rescind this. So this is a shifting argument, and they don't answer it straight up and down. Do you have the intention to rescind this contract? No, we've never sought to do that, and seek your $100,000 back. They want to get consequential damages, lost profits. They want to use tort to cloak a breach of contract claim and say, look, we're going to get all of our damages had we had this exclusive covenant. We absolutely cannot do that based upon Canal. Now, the appellant relies upon several other cases, Malt versus RJ Enterprises, Miley and Miley, Burke versus Picone. Look, Burke versus Picone, because they cite this for the general proposition that I can reform any contract based upon fraud. In Burke versus Picone, we were dealing with a purchase agreement that didn't include a parking spot for a condo association. The deed did include a parking spot. They sued to reform the deed to match the purchase agreement. The purchase agreement satisfies the statute of frauds. Finger licking foods. There was a case that the parties didn't agree how rental increases would be performed. The court expressly found an ambiguity in the written document that they allowed parole evidence to come in to reform it. We don't have any ambiguity in the written document. Malt versus RJ Enterprises.
I think that's what I pointed out with regard to 4.1. It's pretty clear on its face. That's why I was trying to find out what was going on with this pleading to find out if one could arguably amend.
Right. And then RJ Malt.
Comfortably that I've gotten the answers from both parties.
Right. So RJ, I just want to go through the reformation one more time. The RJ, this is a case the appellant cites. The building was misstated in the lease, so they reformed the lease to match the square footage of the building. Again, that's an existing fact. I would submit there's no more existing fact than the square footage of a building at the time the lease is entered into. So those are the types of things that can serve as a basis for fraudulent inducement or reformation. The misrepresentation or mistake of an existing fact. This is an oral promise that falls squarely within the statute of frauds, and under Canal, we cannot use a tort or anything else to try and modify the contract. This is back to the contract, which clearly states, or actually clearly has an absence of a restrictive covenant. We cite the White Star case. We cite Parkley House and the Furgotts case that says that exclusive covenants and leases are within the statute of frauds and they need to be clearly expressed in a written document. So we don't have that here. I've covered recension. Briefly, the appellant does cite some cases that rely upon the independent tort doctrine that says torts do exist independent of the contract. We cite the Stearns case that talks about, well, if the existence of a tort turns on interpretation of the contract, do we rely upon the contract to determine whether somebody was fraudulent? That's not independent of the contract. So that's another ground as to why they're not allowed to bring this tort here, because the parties have a contract and this is not a tort independent of that contract. I think I can rely upon my papers for the rest of it. I'll conclude by saying that if the court looks at the motion for leave to amend, it's strict, they're simply attempting to enforce an oral contract through a tort. And that can't be done whether they call it reformation, whether they call it a tort, whether they call it damages. And for those reasons, we believe the trial court properly addressed this issue and denied leave to amend and dismiss this case with prejudice. As it stands, this idea that they can bring a claim for damages based upon recension has never been brought before the trial court. So it shouldn't serve as a basis of reversing the trial court when she's never had the opportunity to address that issue. That's never been presented, not preserved, not presented, and shouldn't serve as basis of reversal.
And to get there, we
with that
first
time,
have to determine whether we have jurisdiction or not.
Yeah, and respectfully, I don't think there's jurisdiction. Not only Judge Rothstein pointed out that does a landlord have a complaint pending, the appellant filed leave to amend because the court did give him leave to amend the deck action that was pending to say, right. And she's only said that, look, you can't redress a breach of contract falling within the statute of frauds as a tort. That's been dismissed with prejudice. She even left the door open to say, if you can find a different way to do this, I'm all ears. And she gave him leave to amend the deck action. But as this was pled, this was gone. And so the service to reverse the trial court when she's done nothing wrong would be inappropriate. And I'll yield the floor to the appellee, Mr. Blunt.
Mr. Frazier and Mr. Blunt, you have actually about 10 minutes. So
super. Because Steve Blunt, Your Honor, on behalf of Naples Supermarket Corporation, which I may refer to in my argument as NSC at times. The argument went a bit of a different direction, and I have to make a few points, and I want to make sure that I point out some simply inaccurate statements by appellate counsel. One of them was, and I put down a quote that he said he basically dismissed the competing tenant without prejudice. That's simply not true. There's no 1.420A voluntary dismissal of my client. My client was included in the second amended complaint. So that's just false. Secondly, and to Judge Casanueva's point, I would presume that if a party who was arguing improper competition and I'm losing money because the grocery store next door moved in, I would assume that if they wanted rescission, Your Honor, they would vacate. And because they would have a duty to mitigate their damages. They would say, I'm vacating, I'm shutting down my grocery store because you tricked me, you defrauded me. That's not what happened here. And that's not what was alleged here. Never been argued, never been presented to the trial court. It's simply not true. And finally, I would note that he said another thing about Cannell in this case that's not accurate, because Cannell is directly on point. He said, we're not talking about separate properties here. We, in fact, are talking about separate properties. He seeks for his lease for units 1 and 2 to place a restriction of use on units 3 through 18. That's no different than the Cannell case where they said, when you sold me my property that was not waterfront, you told me you were going to put a restriction for use on the waterfront properties so that I could cross them to get to the water. We are talking about two different properties, and that's why the statute of frauds absolutely prohibits any attempt to force a restrictive covenant on the landlord for the other units in the shopping center. Okay, so that was not true. But back to my basic argument that I presented to the trial court and in my briefs, Your Honor, the contract here is unambiguous. I mean, it's very simple points. The contract is unambiguous. Competition is privileged. And the second amended complaint was very creative and was a distinction without a difference. And in order to demonstrate that, Your Honors, I'd ask you to look at the relief requested as to my client. It was only injunctive relief, no damages, no attorney's fees, no nothing. Simply, I want you to stop being a grocery store. I don't want you to open a grocery store. Those allegations were contained in paragraphs 37 through 43, 77, 78, and most importantly, 81, where these are the horrible things my client did. They took actions in furtherance of the conspiracy by entering into the NSC lease agreement, registering a grocery store fictitious name with the Florida Department of State, by building, developing its grocery store location within the subject property, and by taking actions in furtherance of opening its brand new grocery store business within the subject property. My client opened a business. That's it. It's important to note that So then you look at the contract. Any claim for injunctive relief as to my client would have to arise out of the contract. As I think the court has duly noted, contract is unambiguous. I won't bother reading the provision. I think the court has made it clear that they agree with that contention. But, you know, we have to go to the four corners of the complaint. And if there's no exclusivity within the contract, then there can be no claim against my client. And that takes us to the International Expositions case, which I cited to the trial court as well as in my brief. Very simple case. City of Miami Beach leases convention center property for an auto show to be held in, I think, early February, signs a long-term lease, and then turns around and rents to a competing auto show in November of each year. So obviously the first auto show is going to have the jump on the customers, and it's going to harm the second auto show coming in February. Everybody knows that. And the court says, yeah, but there's nothing in the contract that prohibits the City of Miami Beach from doing that. They should try to rent the convention center as much as they can. Just as in this case, the landlord should attempt to rent as much of his property as he can. He's in business for a purpose. And the International Exposition case makes it very clear the court can't write anything in there to stop the competitor from moving in. That competition is privileged. And then that takes us to this creative second amended complaint. And remember, I started this argument by saying the only thing they asked for as to my client was injunctive relief, saying because he opened a grocery store. The second amended complaint still only seeks injunctive relief as to my client because he opened a grocery store. It doesn't contain the words tortious interference, except for in the reservation of rights section. Despite appellants' attempts to characterize their second amended complaint as having containing my client as a defendant, a nominal defendant or necessary party, none of that language exists within the agreement. They simply didn't call them Naples Supermarket Corporation. They called them the competing tenant and said, we want an injunction against the competing tenant. So where does that leave me, Your Honors, as a
Mr. Brown?
Yes.
I'm sorry, I'm just looking at count one of the second amended complaint right now. And I mean, I still only read it as seeking injunctive relief against the landlord, not against the competing tenant. So I want to figure out what I'm missing, because I think I must be missing
Well,
something.
the language, Your Honor, I think it gets very creative, but what it attempts to do, and let me just pull up that, it characterizes the second, it substitutes for Naples Supermarket the competing tenant language, and it talks about the covenants and the covenant breaches. And then it says it wants to prohibit the landlord from exercising the covenant breaches, is my recollection of the language, which would include
So it sort of
disallowing,
like indirectly implicates the competing tenant.
if the landlord cannot do business with the
Then
competing
obviously.
tenant, then the landlord cannot do business with my client. And remember, I'm still in as a defendant. What am I defending? I'm showing up at depositions. I don't know what elements of the cause of action I'm defending. I have no, what am I doing here? And you know, there were requests. This is obviously not within the record, but there was some reference to it in the appellant's brief, so I feel it fair for me to mention it. There was some communication with the counsel saying, "What are you doing? If drop me, and I'm out. I'm gone, and we don't have a problem." But that didn't happen. At the end of the day, it's the same allegations. Don't open or run a grocery store next to me. And it's the same request for relief. Don't open or run a grocery store next to me. And the argument is very circular. And also, Your Honor, ignores the temporal context, which I think goes to the subject matter issue brought up by Judge Rothstein. If they're asking to use the fraud to somehow reform this agreement so that it would say something different today than it said 2.5 years ago when all this started, or a year and a half ago, or 2 years ago when my client started looking at this plaza. So somehow my client was to know that this contract didn't say what it says unambiguously, and that somehow my client was to know that there may have been some discussions prior to entering. I mean, it's to have my client be liable in any way, shape, or form, which is why injunctive relief could never be had against the landlord in any event under these circumstances. And finally, the only other point, I just come back to my very first point, which is if the intent was to dismiss my client, it was very simple under 1.420A to dismiss my client prior to filing any motion to amend. Then I wouldn't have even been at the hearing. Could have amended and argued whether or not I was my client was a necessary and indispensable party, and then reserved my client if necessary, or reserved my client after they discovered the facts. It's not what they chose to do. They chose to move to amend, keep my client in, request the very same relief through some very creative drafting, which left my client in a position where it just simply had to argue the motion. And Judge Creer ruled correctly, and I included in my brief Judge Creer's comments to counsel for the appellant at the hearing, where she stated repeatedly, but you know this, the rules don't allow you to backdoor this. What do you, and you know that I can read, this is English. So the remainder, I would rely on the brief, and I yield the floor to Mr. Landcamer.
Thank you. Mr. Landcamer, you're up for 5 minutes.
Thank you, Your Honor. With respect to the competing tenant appellee, I think that the most important issue is the standard for dismissal of claims with prejudice. This court has held that dismissal with prejudice is only warranted when no possible allegations of fact and no possible legal theory can support a viable claim for relief. There have been proposed additional pleadings in this case that have facts that have occurred. They could be pled as supplemental pleadings potentially or otherwise, where things have been done by the competing tenant that, if fleshed out with the facts and discovery, they could create causes of action and be indicative of causes of action. That's an issue, because if they're dismissed with prejudice, then those claims can't come back. As a general matter.
Do you mean, Mr. Landcamer, just to clarify, is that the thing, what was it, the grease trap or the septic, or is that what you're talking about? Like how they reported you, or those things that you mentioned? The landlord provided the property as a turnkey operation to a buyer about a year before my client bought. It was tendered again as a turnkey operation with my client bought. There were representations made that the property was in condition to be operated as it had been operated. My clients did that, and then all of a sudden they start getting reported. Additionally, there was an issue with the septic tank on the property. It's not a public sewer, it's a septic tank, and there wasn't enough room on the septic tank for both the competing tenant and my tenant to operate it. And my client was basically forced out of operation, or at least a large portion of its operation, in order for the competing tenant to get enough access to the septic system to promote its business. And those would be claims basically completely independent from anything having to do with the exclusive use claim, right?
Arguably, but they would have the same title. They'd basically be civil conspiracy and tortious interference type claims. Yes, Your Honor. As a general matter, when a motion to dismiss is granted for failure to state a cause of action, the trial court is required to exercise utmost liberality by giving the pleading party every opportunity to collect defects in the challenged pleading, by dismissing it without prejudice and with leave to amend, provided that the pleading party requests leave to amend. So indeed, the failure to do so is generally considered an abuse of discretion. In this case, my client was in front of the trial court one time on a motion to dismiss. The trial court's determinations as to the sufficiency of my client's allegations in their complaint, never on the initial complaint, for the first time at the dismissal hearing on the first amended complaint, my client was never given an opportunity to amend its pleadings pursuant to its second proposed amended complaint or its third amended proposed complaint. So never after the judge gave her ruling as to her perception of the pleadings was my client given a free opportunity to amend to comport to whatever issues existed. Instead, my client's request to amend was rejected, and most of my client's claims dismissed immediately on the first view by the judge in this case. I don't think that that complies with the court's general standards for dismissal with prejudice, and it's the appellant's request that this court take that into consideration and allow, after the appellant has had an opportunity to hear the issues of the trial court, this court, and counsel on the respective other side, to reformulate its complaint at least one more time so that they can attempt to address these issues and potentially have their case appropriately dismissed with prejudice, or otherwise go forward if that is not what occurs.
Your time is up.
Thank you. On that, I think I just gave what my client would like this court to do. So thank you very much for the time.
All right, thank you. Thank you all. In order to leave our virtual courtroom, you need to click the aptly labeled button called Leave on your Zoom screen, and you'll go away, and we'll call the next case.
Thank you, Your